Okay. I'd like to, good morning, Your Honors. May it please the Court, I'd like to reserve 4 minutes for rebuttal.
Would you state your name for the record, please?
Yes, this is James DeSimone. I represent MAR, the minor, as well as the mother of Mr. Rivera, who's the decedent in this case. So, the district court erred when it ruled that there were no triable issues of fact on the officer's conduct in constituting excessive force, and I'd like to focus on 3 areas here.
Before you do that, I have one question that goes to our jurisdiction, and that is, it was not 100% clear to me that you have forsworn the possibility of a Monell claim in the future. Are you prepared to say that you will not try to revive a Monell claim no matter what at this point?
We relinquished that claim. We relinquished that claim. I think that this was, the reply brief was intended to communicate that we relinquished that claim.
Okay, I just wanted to clarify.
The Sneller versus cases, as long as there's no manipulation here, that we're trying to somehow get it back. I don't think that it was candidly fully thought out without versus with prejudice when those claims were dismissed. But for the record, we are relinquishing those claims, okay, and we will not attempt to reinstate it after this ruling.
Okay, thank you. And go ahead with where you were going.
I have a somewhat foundational question that perhaps you can discuss it during your argument. But the district court divided the incident into 3 separate analyses. The first step, the first part were the kneeing in the back, the pressure down, the second taser, and then third back to the pressure downward. Was that appropriate, or should the entire event should have been considered as one episode?
I think it's appropriate for the analysis, but I do think you have to take in consideration each and every uses of force. In other words, when we look at that third analysis where they have someone hobbled and handcuffed, prone for 2 minutes and 35 seconds, the officers know what happened before then. It shouldn't be just viewed in isolation. They know that he's been shot with a taser 4 times and has that electromuscular current. They know that when they first approached him, he's completely unconscious. I think what the court did here was indulge the inferences in favor of the officer's interpretation, and in fact went bent over backwards in some ways. I mean, an illustration of that is the court's, I'm sorry, Judge Graber.
I was just going to follow up on what Judge Thunheim was asking, because part of the analysis is whether the officer's actions were ones that they should have known that clearly established law told them they shouldn't do. So just for the sake of this question, which I hope bears on what Judge Thunheim is getting at, let's assume that we were to conclude that the use of the taser was wrong under clearly established law. Do we have to also find that everything else that they did was wrong, or can we just say there's at least one issue of fact and back it goes?
You don't have to do that, but I would urge the courts that each and every...
No, but I'm asking you sort of as a theoretical matter. Do we have to find that each thing that they did was wrong, or is it enough to say that, just hypothetically here for the moment, that at least one of the actions they took was wrong under clearly established law, and that is sufficient? Wouldn't that be sufficient for
Absolutely.
An issue of fact?
Absolutely. And I think that, and that's why I was going to go to the taser first, because I think that that's the most obvious and part of the erroneous ruling.
Would it go back then for assessment of the totality of the circumstances, or would it go back only for an assessment of whether the taser implementation was incorrect?
I think it depends on how Your Honors would want to couch that ruling, but I would urge Your Honors to say that there's triable issues of fact on each of those 3 instances that constituted excessive force here. I mean, and we know that if we look at the taser itself, you have in this instance the Board of Police Commissioners specifically found that Mr. Rivera was not violent. It did not pose an immediate threat to those officers. They reviewed the complete record. Now, if you have folks on the Board of Police Commissioners that are making that determination, then a judge sitting in the district court should not be able to say, well, I find there are no triable issues of fact, because reasonable people found it otherwise, that he was not a threat when that taser was used. And then if we look at the excerpt of record on 634, which is the LAPD's use of less lethal weapon, it specifically states, the courts have held that less lethal force are capable of inflicting significant pain and may cause serious injury. So you have in the very policies of the LAPD that they are putting those officers on notice that their policies are not just LAPD trying to make sure that people are safe, which they should, but we are being told this by the courts, that we have to do this, and that you cannot use a taser unless someone is posing a direct threat of violence towards those officers. And when we look at the point in time when the taser is being used and the different factual disputes and the characterizations, I mean, the court starts out its analysis first saying that Mr. Rivera walked down the embankment. There's nothing in the record. The airship said he rolled down the embankment. He gets down there in a matter of seconds. Takes the officers 20 to 25 seconds to walk down there. When he's down on that embankment, he is completely unconscious. The court finds, and it's finding a fact, that he deliberately was ignoring commands to show his hands. Well, if you look at the various areas of the videos, his left hand is up by his head, his right hand is out here. They can see his hands.
Hands were visible, it appeared to me.
Right. It's not just what you could see on that body cam at a point in time. It's what the officers can see. They have officers up on the ridge providing cover. And so in the cases where you have a rapidly evolving situation where tasers have been held, that the law is not clearly established, you have someone who is actively fighting with one officers. The AB case that the court ruled on, that I believe you were on that panel, Judge Graber, in that instance, you have civilians all around. You have an individual who is fighting one officer and actively fighting an officer when the taser is used. Contrast that with the Rivera case, where he's prone the entire time. He's face down. You have multiple officers. They never lose control of the limb. The courts
the officers, when they arrived, had been told that he was a burglary suspect. Burglary can be a violent crime, and the judge seemed to take that into account. Could you address that issue for a moment, what their knowledge was when they arrived on the scene?
Well, it can be a violent crime, but in this instance, you basically have someone who's trying to get into doors, seeing if they're locked or unlocked, and then moving on when he wasn't able to go into the house. So there was no crime of violence. There was no weapon.
Attempted burglary at best is what you're saying.
Correct. And what was also being communicated to the officers is that he's unsteady on his gait. He's not. He looks confused. I mean, this is clearly a person who is under the influence of something, or perhaps having a psychotic episode. The officers can't be sure, but the care that should be given to him should be consistent with someone who, when they find him, and of course we have to evaluate in these situations on a moment by moment basis. So. It's not like he's in the middle of a burglary where people are at risk when they confront him. Let's look at the reality of the situation. This guy's completely unconscious at the bottom of a wash after he tumbled down. And so the court says that he's deliberately ignoring these commands. And again, that's a factual issue. A reasonable trier of fact could say he wasn't ignoring them. He just didn't hear them because he was unconscious. You only see his eyes open after the officers pounce on him. Now, I think we've cited the case law with the Jones case and the Bonnevart case that clearly shows that that you cannot use repeated shocks. Remember, he just doesn't tase him once. He tased him 4 times in rapid succession while he's under control. The court also finds that it's Mr. Rivera that is preventing his arms from being moved behind and putting his arms into a position. Well, it's true that Mr. Rivera clasps his hands behind his head at one point, but the officers actually have both arms, and you have one of the officers kneeling on his bicep, on his right arm. How's he? Man who is under control of LAPD officers and was gratuitously and unnecessarily tased while he was in that helpless position, after he came to after being unconscious. And it goes back to the basics. If the force is not necessary, it's not reasonable. And in that instance, you had officers who just could have held down his leg at that point, completed the handcuffs.
I want to make sure I understand the record on the initial pressure that was placed on Mr. Rivera. Two officers with a knee on his back with about half their body weight on that knee, and then another officer with an arm on the upper torso putting pressure there. Is that what the record shows?
Well, I don't know if you could say that it was half. I would say that it was more 75 to 90%. If you have your knee on someone and you have your leg stretched out for balance, but your knee is pressing into their back, you're really putting more of the entirety of your weight. So I would not say that just because, and the court found that
I think the question may be more basic than that. Two officers, both with their knees pressing on him, plus one more with an arm on the torso. Is that correct?
That's correct, but there was a fourth officer on the other side. So in other words, you've got yes, but then you have the other officer pressing into the bicep. And I see that it's 3 minutes and 40 seconds. I just want to get to the positional asphyxiation. There are a number of out-of-circuit cases that have for years shown that there is a consensus that you just do not put someone on their stomach when they are handcuffed and hobbled. And the court, in order to justify that, says that our client, well, the decedent, voluntarily rolled onto his stomach. That's absurd. He's in handcuffs and hobbles. You have an officer holding up the hobble. He didn't voluntarily roll onto his stomach. He stopped moving once he rolled onto his stomach. But those officers, during that 2 minutes and 35 seconds, are placing their hands down on him, at one point their knees onto him. That is totally against policies. And once again, you have the policies, the excited delirium policies, that say, once you've put those hobbles on, you must put the person into a seated position, or roll him on, or put him on his side if you can't put him in a seated position. They should have sat him up.
I didn't hear on the video Mr. Rivera claiming that he couldn't breathe. He was grunting and it sounded like a scream at one point in time. Is that significant that he didn't say that he couldn't breathe?
I don't think so, because, and I'll tell you why. During that period of time when he's on his side, before he's placed on his stomach, he's convulsing. In fact, if you listen to Officer Romero's at the end, he said he was convulsing. He was like a fish out of water. A fish out of water. How is a fish out of water a threat? Very telling. So while he's not saying that he's not breathing, he is indicating by his behavior that he is in medical distress and should have been treated as someone in medical distress. They should have sat him up. His legs are tied, his hands behind his back. You got 10 officers around him, no civilian in sight. Why are you putting him on his stomach? And you have the finding of the coroner, and we have Dr. Amalu's declaration that show this was a cause of death. The use of the taser and the positional asphyxiation was a cause of death, and it went against policies. And in the Drummond case, back from 2003, you could take into consideration that the policies show that the officers are in clear notice that they violated clearly established law.
During part 3, he was on his side for a period of time, not sure, a minute or something like that.
55 seconds before he was rolled onto his stomach.
And did the officers roll him back on his stomach? Is that clear?
I think it's clear that he rolled onto his stomach when the officers were in physical contact with his body. I'm not going to say that they propelled him on his stomach, but they did allow it to happen. But then once he was on his stomach, they pressed down on his back with their hands. And at one point, you have one of the officers kneeling on his back, which shows that the pressure is being applied. It's completely inappropriate. You need at that point to make sure that you don't kill the guy. And instead, they did the exact opposite of what they're trained to do, and it resulted in a man's death. I have 35 seconds, so I'll reserve that.
Very well. We'll round up to 2 minutes.
Thank you very much, Your Honors. Thank you, Your Honors. I'd like to follow up on a couple of those points. I mean, one, it's a triable issue of fact as to whether or not this is the use of force created the asphyxiation which led to his death. I mean, the way this works is, and this was explained in front of the whole country in the George Floyd trial with experts, one of them who was an LAPD sergeant, but the compressive force causes the difficulty breathing. That leads to a cardiac arrest and the cardiopulmonary infarction, it's called, not infraction. and then the deprivation of oxygen is what ends up causing the death. And I think in terms of that tribal issue of fact, we have Dr. Amalu's declaration, which establishes that really the pressure that was put in, you have to look at the totality of the circumstances, that it was 8 minutes. And I really do think this was because everybody in that team knew that the taser was being used. This is really an integral participation act where all of the officers can be held liable for the conduct of the whole. And I think that the initial, if you look at the case law on the initial interaction between these officers, when you have someone who's not moving at all and they're immediately digging their knees into his back like that, what you have is an interpretation as Mr. Rivera's actions are consistent with him struggling to survive and live and breathe and not fighting the officers at all. He never hits them. The only thing, in fact, there is a tell when counsel says in order to justify the taser use, she says he's actively resisting. He's not restrained. Well, that's not the standard. The standard under the policies, under the case law, is that he has to be providing a violent threat to those officers, and that's not happening. You could see at one point, as the taser is being used, involuntary movement where he kicks his leg back this way. He's not kicking the officers. It's sort of, it's a reflective action to the pain that's being caused by the taser. So you can't tase someone and then have the person react to that taser and then say, oh, well, there, he's acting violently and that justifies the taser use
Counsel,
because now he's moving his leg.
Would you answer the question that I asked opposing counsel? Is this a case in which mediation has been attempted? And if not, is that something that you think would be fruitful?
I would honestly think that it would not be fruitful without a decision from this court. With my interactions with the city of Los Angeles, I think they need guidance from this court. We just would not. I don't see that as being fruitful. Not that we wouldn't be willing to do it, but I just don't think, candidly, on the city's part, that we could have a meaningful mediation without that determination. So I do want to point.
You're over, so make it quick.
Oh, I'm over. Then if I'm over, I did a survey of cases in other circuits because I didn't think we had really addressed that adequately in our briefing, frankly, when I started preparing. And if you look across the board in terms of the notice that police agencies are given on positional asphyxiation, my first positional asphyxiation case was as maybe a young lawyer in 1990. I mean, it's a surprise. Police officers have been trained on this for decades, that when you have someone in hobbles and handcuffs, you sit them up, you don't put them on the stomach. These officers violated those policies when they put him for 2.5 minutes on the ground and pressed their hands into it. So I think the taser use is bad. That positional asphyxiation should also be a reversal, and even the initial interaction with these officers, where instead of giving him commands as they're getting closer, and that tribal issue of fact, maybe at one point they can't see the hand, but once they come near him, they could see his hand to the left of his head. The fact that he couldn't see it at one point in time is not dispositive. But at that point, you say, hey, put your hands behind your back. We're going to arrest you, instead of immediately physically attacking a man who's unconscious. You have a fight or flight reaction, and his reactions are consistent with someone struggling to survive, and in no way does he ever strike or fight those officers.
Is there any public information on the cause of death?
There's the coroner's report that's part of the record. Absolutely. The coroner.
Is it sealed? That's opposing counsel said that's sealed.
I don't think it's sealed. It was provided to us.
Well, that doesn't mean it's not sealed from the public. Of course, you would have the opportunity to see it. And we will too. I mean, we've got the record.
It's just a matter of whether we can discuss it here in this setting.
I understand. Well, we have the Dr. Amalu declaration that has been filed, not under seal, which would talk about the cause of death. But certainly the coroner's, I could say this, I think the coroner's findings are consistent that the officer's use of force was what was the catalyst to causing Mr. Rivera to die that day.
All right, thank you very much, counsel. Thank to both of you for your briefing and argument today. This matter is submitted, and we'll move on to the final